Hello, analyzers. Thank you for joining me. Hello, hello. Hit that like button and do join our chat. I want to know what your questions are on the Elizabeth Holmes case. We're going to talk about her motion for release pending appeal. In other words, Elizabeth Holmes wants to stay at home while her appeal is pending. Do you know how long it takes to get an appeal decision? In California, it could be up to a couple years. So, will the judge grant Elizabeth Holmes' request to stay at home until the Court of Appeal makes their decision on whether to uphold these convictions, overturn them, require new sentencing? We'll have to see, because her appeal brief has not been filed yet, so we don't know what her issues are on appeal. However, in this motion that she filed requesting release, it's called a motion for release pending appeal, she does indicate issues that she may appeal. And I'll get to why that's important and why words matter. So please do join our chat. Please subscribe to join the chat. Say hello. Let me know that you're there. Hello, hello, everybody. Hit that like button. Thank you very much for hitting that like button. Okay, so for those of you who don't recognize me and haven't seen my plethora of videos on the Elizabeth Holmes trial, my name is Michele Hagan. I'm a legal analyst and a former prosecutor. I'm a California attorney, and I was in the courtroom, I watched the trial, and I gave a lot of legal analysis, both locally, nationally, and international media outlets. So I know more than enough about this case. So you're welcome to ask any questions, put them in the chat. So in this live tonight, and thanks again for joining me. Happy Martin Luther King, civil rights. So put your question in the chat. So we're going to go over tonight the 10 reasons. Actually, there are 11 reasons why she wants to stay at home. And we're going to look at the 4 factors in which the judge weighs to determine whether or not Elizabeth Holmes can stay out of prison pending appeal. So do let me know. Do you think the judge is going to grant it? I'm curious. Do you think the judge is going to grant it or deny? So is the chat working? I'm looking to see. I'm not seeing any chats. I'm hoping they fix this issue. We had this with the last live. Well, you can always put it in the comments underneath the video when it's posted. And by the way, this video is for education information, simply my opinion, my analysis. So I want to know what your analysis, and more importantly, what are your questions? This is your opportunity. I'm live. Ask me your questions. And if you want to support my work, I much appreciate it. I'll put a super chat link in the chat box, as well as I will post it in the box below the video, in the description box. Also, if you want more extensive coverage of these 10 reasons, I did a live analysis. If you look at the video under the live tab, it's called Balwani Sentencing and Elizabeth Holmes Stay Home. You can take a look at that video I did. I think it was last month. I think it was around December 9th. That'll give you, I walk you through all the 10 reasons that she's asking. Tonight, I'm going to do an expedited or a shortened version of that because I want to get to your questions. I'm live, so ask me your questions. Hi there, chat is working. Thank you for letting me know. Okay, and thank you for subscribing to my channel. Okay, so analyzers, what are your questions? Any questions? Thank you to those of you who voted, by the way, to choose this topic. And also thank you to many of you who actually sent me your questions. I'll get to those too. So shall I go ahead and get started? Do hit that like button. And if you want to contribute, did I say this already? In supporting my work, there's a PayPal link in the description box if you want to do a super chat. Much appreciated. And by the way, thank you to those of you who do and have contributed. I truly appreciate it. And thank you to all of those of you who have supported this channel and continue to support this channel and continue to ask fabulous questions and offer great analysis. I really appreciate it. All right. So again, welcome. And let's take a look at let me just back up, give you a little backup information in case you popped on this channel. So Elizabeth Holmes started a company called Theranos. It's a blood testing company. In other words, I think the motto was one small drop will change the world, something like that, where you could go in, you could waltz into Walgreens and have your blood analyzed. There was a bunch of different blood tests you could take. Anyway, she and the COO, Sunny Balwani, were both charged with 12 counts of wire fraud. In other words, defrauding investors, allegedly, defrauding investors and patients, investors to the tune of about 144 million. They were tried separately by jury trial in San Jose, California. Elizabeth Holmes was convicted on 4 of the 12 counts. She was sentenced to 11 years, 3 months in prison. She's looking at a federal prison camp in Texas. Surrender date at this point is April 27th for Holmes. For Sunny Balwani, he was convicted on all 12 counts. He was sentenced to 12 years, 11 months. He's looking at surrendering, I think it's March 15th in Lompoc Prison, which is near Santa Barbara, California. Okay, so let's get to the questions that you have. Let's see. So, Nira, will the strong evidence of trial presented by the government have an impact on the judge's decision to report? Well, actually, there's surrender dates, which I just went over. So hopefully that answers your question. So assuming Elizabeth Holmes loses this motion to stay at home, basically, while the appeal is pending, if she loses it, she will surrender to the Texas facility on April 27th. That's the scheduled date. Okay. Now, give you a couple updates here. The updates are the motion, the hearing on this motion to stay at home. I'm going to call it the stay at home motion. That was scheduled for January 23rd. So this coming Monday. Well, it looks like it's going to be postponed by agreement by both sides. And the new date, it looks like, I haven't seen the order from the judge yet, but the new date, because both are agreeing, both sides are agreeing, the new date's going to be March 17th for the hearing, which is a little interesting because it's 2 days after Sunny Balwani is supposed to surrender. Anyway, so what that tells me, and also the prosecution has to file their opposition to Elizabeth Holmes' motion to stay at home. That opposition is due this week. I haven't seen it yet. Today's a court holiday. I am wearing my suit, but that's just, I thought I'd wear my suit anyway for the video. So, okay. Let me see what other updates to give you. It has been reported by TMZ. I haven't been able to clarify this or confirm it, that one of the sentencing terms post-release, so release from prison, on these counts, Holmes and Balwani are both going to be under what's called supervised release for 3 years. That means probation. And one of those terms that's being reported by TMZ is that Elizabeth Holmes has to attend mental health counseling. Now, that could be a common term to kind of assimilate a defendant back into civilization, so to speak. So I'm not aware of any evidence that was presented. There was no evidence presented at trial regarding any mental health issue. I'm not aware of any evidence. I'm not aware of any experts, doctor's letters or anything suggesting there's any mental health issue. The mental health condition, the mental health term, I should say, is something that I'm sure is probably required on most defendants, especially when they're serving a substantial prison time, that somebody keeps an eye on their mental health as they transition back into society. Okay, so let's see. Questions. Why do you say allegedly? Well, because I initially said that. Okay, she was convicted and so was Balwani. All right, so, however, the convictions are not final until the appeal is final. So it's not done until the appeal is done, okay? So because the convictions are still, she may be filing an appeal. It looks like she is, and Balwani, I'm sure, is going to be filing an appeal. with the Court of Appeal, that could take a couple years to get a decision. So the question is for this video is, will she be granted her request to stay at home while the appeal is pending? So let me know, do you think the judge will deny it or grant it? Okay, so let's go ahead. And if you have any other questions regarding any part of the trial, any evidence, anything to do with the Holmes trial, the Balwani trial, put it in the chat. I'm here live. Take advantage. All right. So what else did I want to tell you? I probably will do another live when we get the prosecution's opposition, what the reasons are as to why they're going to ask the judge to deny this motion to stay at home. I'll probably do a live probably later in the week, possibly Saturday. I have to see what my schedule looks like. And just to remind you, the appeal, I believe Holmes's, the appeal process starts with the defendant filing an opening brief. Okay, and I believe, and in the opening brief will indicate what the issues are on appeal that Holmes is contesting. That opening brief to the Court of Appeal, I think, is due approximately March 5th. So by March 5th, we'll have a better idea of what her appeal issues are, because this motion, the stay-at-home motion, is only telling us what she may appeal. Okay, what issues she may appeal. So hit that like button. Thanks again, everybody, for joining me. Okay, so let's go ahead and I want to tell you what the law is. I was a law professor. I've trained a lot of lawyers on how to try cases, how to do an opening, closing, etc. I'm a trial expert, right? I'm also a trial lawyer. I've tried a bunch of cases myself, so I know of what I speak. So anyway, I want to talk to you. I'll put my law professor hat on. So what is the law that the judge needs to apply here to decide whether or not to grant or deny this motion, this stay-at-home motion? Well, the judge considers 4 factors. 1, is she a flight risk? Is she a danger to the community? Well, the defense has argued no, she's not a flight risk. She's not a danger to the community because she has made every court appearance. She has posted the $500,000 bond with her parents' home as the collateral. She's also pregnant with her second child. So all of that incentivizes her to comply with the court's conditions. So the defense is arguing she's not a flight risk. If you think about the Andrew Tate case, Andrew Tate, the social media influencer in Romania who got arrested on trafficking charges, he's contesting. He wanted to get out. The judge said, no, you're basically a flight risk. So they're keeping him under arrest for another 30 days. And I did a video on that if you want to take a look at that, because the Romanian court, unlike the United States, you can't hold someone under arrest in Romania up to 180 days. So interesting case, interesting video. You can take a look at that. All right. So the other factors are, the prosecution may argue that she is a danger to the community because she's apparently working on some chemical patents or something. I don't know. I don't know if they're even going to say that. And I don't think it's the most important factor here. So second factor, I got to look at my notes. It's a holiday. Here's the one that I think might trip the defense up. She may lose it on this one. The second factor is this motion is a delay tactic. And the defense is arguing, no, it's not a delay tactic. She basically has viable issues on appeal. I'm sure the prosecution's going to say, no, this is an appeal tactic. None of these issues are legitimate. She's going to be denied, etc. Okay. But, it's up to the judge here. It's in his discretion as to decide whether she has met all 4 of these factors. So is it a delay tactic? We'll have to see what the prosecution says in their opposition. Hi, Fungi. She will use her children as a reason to stay home. Yeah, she's been trying that, the judge, I think, has already taken that into consideration. Okay. So I don't think so, because if you think about it, I think she's probably going to be delivering this month, if I'm correct on that. So February, March, April surrenders. So it's 3 to 4 months of bonding with your second child. We'll have to see. So I don't think This motion is not uncommon, by the way. A lot of defendants will file this motion, especially when they're looking at substantial prison time, and especially when they're planning on appealing their convictions. Okay, but thank you for that question. This is delay tactic. Yeah, I think that's what the prosecution's going to argue, and I think, there might be great consideration given to that factor. Okay, so the third factor she has to meet. This is another one that's interesting. Will the appeal raise substantial questions of law and fact? Okay, questions of fact, that's the jury's province. Whether it's a question of law and the judge made an error on it, that could be a legitimate issue for appeal. So the question is what's substantial? You know me, I'm all into my words matter. What substantial issue? A substantial issue of question of law or fact. Substantial means the judge's rulings had to be fairly debatable. Fairly debatable. That means another judge could have thought, well, that's debatable as to whether I would have kept that evidence in or not allowed the deposition, the SEC deposition testimony that Balwani gave, or keeping out Rosendorf's prior and post employments with those 3 labs that were investigated. So I'll get to that too. But anyway, so is it fairly debatable, any of these rulings? And again, it's the judge who's going to be considering his rulings. And in my opinion, this judge has been very conscientious, has made clear record, as far as I can tell. And when a case goes to the Court of Appeal, the Court of Appeal doesn't take any new evidence, doesn't call any witnesses. It's based solely on the transcript of the trial. Everything that happened in the trial, the court reporter took down, as well as what the law says, as well as what the arguments are in the briefs that are filed by both sides. Whether the Court of Appeal gives an oral argument, it's up to them as to whether they allow the parties to orally argue, to appear in front of the Court of Appeals. We'll have to see. So we're just in the very beginning stages. So were the judge's rulings fairly debatable? And I'll get to that too. All right, so the fourth factor that Elizabeth Holmes has to meet is the appeal likely to result in a new trial? Will the appeal likely result in a new trial? Well, what happened in this case? Elizabeth Holmes filed a motion for a new trial, the acquittal motion, and you can look at the videos I did on that. The judge had a hearing, made a decision, denied the motion for a new trial, right? So will the appeal likely result in a new trial? Well, this judge has already decided no new trial. She can appeal that decision. We'll have to see what the Court of Appeal does. Okay, but again, back to words matter. When I looked at the decision made by the judge, and I think it's in the acquittal video, the judge actually said in his decision denying Elizabeth Holmes her right to a new trial, he said the wording of that decision was, she lied, she worked together, and she conspired. Okay, so those are pretty strong words instead of saying misrepresented. Okay, let me get to your questions here. He gave her more than a fair trial. Fungi. I think, he's that type of judge that was very patient with both sides, very conscientious, very thoughtful. He gave both sides plenty of time to roll out whatever their arguments, whatever their objections are. And by the way, I think Holmes filed 19 pre-trial motions. In other words, 19 motions to keep out certain pieces of evidence, to keep out a witness, to keep out testimony regarding her lifestyle, all of that stuff that was in the pre-trial motions. Okay. Does the fact that she harassed whistleblowers against her make her a danger? Oh, I forgot to mention that. Thank you. Is it Kit Tao? Yeah, thank you very much. I forgot to mention that. I did mention it in the prior video I did. Yeah, I think Erica Chung and Rosendorf possibly, and Tyler Schultz and several other people could say they still are in fear. I mean, if you look at the letter that was written to Erica Chung, if you look at the the testimony that Erica Chung gave, I mean, clearly, that could be a threat to their safety. Maybe they could argue. We'll have to see if the prosecution also addresses that. But I definitely think that's a legitimate argument. Definitely. But the defense might come back and say, well, nothing's happened. This case has been going on for several years. Nothing's happened. There's been no threats, none of that. And that was all. Maybe they'll point the finger at Balwani. We'll have to see. Okay, so let's go ahead and look at the 10 reasons. And actually, I say there are 11 reasons that Elizabeth Holmes wants to stay at home. Here are the 10 reasons why. And then you'd also can say there are the 10 possible appeal issues. She may appeal on these issues. So let's go ahead. I'll quickly go over this. One was Dr. Doss's testimony regarding, he was the last lab director that Elizabeth Holmes hired to come in after the CMS audit. And he's the one that testified that regarding the quality control and how the technology was working. Well, the defense is arguing he should not have been allowed to testify to any of that because he's an expert witness and he wasn't qualified to be an expert witness to give an opinion as to whether or not the technology was accurate and reliable. Well, the government's going to argue, no, he's a fact witness. He can testify as to what his experience was with the technology and what he observed going on in the lab. I don't know that that's a good, that's a winning argument. We'll have to see again what the government says in their opposition papers probably this week, probably filing this week. Okay, number 2, the CMS audit and the sanctions that CMS imposed because they went to the lab. They wrote up a whole bunch of things that they noted. They issued sanctions against Theranos. The defense is arguing, well, none of that should have come in. That was another mistake that the judge made because it should not have come in because it wasn't relevant as to Elizabeth Holmes' state of mind because she wasn't involved with the lab, right? Do you remember the Holmes defense was pointing the finger at Balwani? And that may have been why Elizabeth Holmes wasn't convicted on the patient counts. I don't know. I'm just speculating here. Okay, so is that going to be a legitimate argument that she didn't know? Well, I invite you to take a look at the many videos they did on the text between, I think one of them is called Revealing Text between Sunny Balwani and Elizabeth Holmes. And you could see how he was texting her, that the lab was a effing disaster zone. So he was complaining about several of the employees, etc. So clearly, I'm sure the prosecution can argue, yes, she knew what was going on in the lab. Okay, let me look. Pungai found Holmes will argue as much as she could and hope something will stick. Yeah, well, that's what any good defense attorney does, right? You need to bring up all these issues because if you don't raise them, then you can't raise them when you go to the Court of Appeal, right? And there's very few new issues you can raise. So, and the defense is there. We're there to defend our clients, to do the best that we can. So filing a motion for a new trial, we'll call it a stay-at-home motion, filing an appeal, those are all common motions, or I should say common procedures that defense attorneys follow, okay? Because they're testing the evidence, they're testing the convictions, they're testing the rulings, whether the judge made a mistake. And again, it's a mistake if the judge made a mistake. It doesn't have to be reversible error, okay? So it's not a higher standard, it's a lower standard. And again, this is the judge, the trial judge, reviewing his own decisions here, okay? So keep that in mind. All right, so number 3, and we got 10 total. So number 3 is the judge should not have allowed the testimony regarding the voiding of all the tests, because when Dr. Doss came in, they voided the test in 2016, which the defense is arguing, hey, that's not fair. That's not relevant because the investors invested prior to 2016. If you look at the indictment video I did, most of the money that was defrauded was in 2015. So the voiding of the test took place in 2016. Defense is arguing that should not have come in because that wasn't a part of what the investors knew or what was going on at the time that the frauds were committed. Okay. So that to me is going to be very interesting. I'll be curious to see what the Court of Appeal does on that one. Okay. Number 4. So again, put your questions in the chat box. Do subscribe to join our chat for those of you who are listening. All right, so number 4 is denial of the motions to suppress evidence and motions to strike. In particular, the defense is arguing the judge made an error in failing and ruling that the government failed to preserve the LIS database, which apparently held all the results of all the tests. And according to the defense, that database would be central to proving the government's case or not, whether or not the technology was fair, accurate, and reliable. Okay. So the defense is arguing that the judge made an error, made a mistake, because they're arguing the prosecution acted in bad faith. Therefore, the evidence regarding, or the testimony regarding failing to preserve the database should have come in at trial. All of the circumstances relating to that. And they're arguing Brady. And Brady is a U.S. Supreme Court case. Whenever the prosecution fails to turn over or preserve evidence that's exculpatory or incriminating against the defendant, but it's a high standard to prove that the prosecutor acted in bad faith. And I don't think they're going to meet that standard. I don't think they met it at trial. I don't think they're going to meet it at now, right? Because here's what happened with the database. It was provided to the prosecutors as part of discovery, but they didn't give the prosecutors the access code. So they were never able to get into the database. So we don't know if it was going to be helpful to Holmes or not. It's a completely different story if prosecutors, destroyed the drugs or, did something that was malicious or intentional and knew the evidence was, or, hiding evidence or something, not turning over evidence. In this case, as far as the testimony and the evidence I remember, is that they never got into the database. So they don't know whether it was going to be helpful or harmful towards Elizabeth Holmes. And by the way, who provided the database, right? Was Theranos. Okay. So that's going to be something I'm sure the government's going to be arguing. And the government might argue that the defense could have called an expert witness because they were saying that and I'll get to, I think it's the 10th item here, was those emails that went between the prosecutors as to what to do about the database, the access code, and the defense is arguing one of the expert technology people within the government was suggesting to the prosecutors that there was a way to preserve this database, which the defense is arguing that the government should have preserved the database. And because they didn't, Elizabeth Holmes is being prejudiced by that. So I bet the government's going to argue, well, the defense could have called their own expert witness at trial and talked about that. I don't know if the judge would have allowed it, but we'll have to see what they say, what Elizabeth Holmes says in her opening brief with the Court of Appeal. Because again, these 10 reasons are what she may appeal on. Okay, so let's go ahead and look at number, I think it's 4. This is the testimony regarding Sunny Balwani's deposition regarding the SEC complaint, regarding who had ownership or responsibility regarding the financials, the financial projections and models that were given to the investors. The judge said, part of it was allowed in, but most of it was kept out. And the defense is arguing that it should not have been allowed in because it was, or I should say, let me see. Let me double check my notes here. Yeah, they were saying that there was an issue around letting that testimony in, whether or not it was incriminating towards Holmes or not. And again, I think it's going to be a legal question that the Court of Appeal is going to have to decide on. I don't think that's particularly compelling, this point, but we'll have to see if they include it in their opening brief. Okay, the next one. limits, the defense is arguing that the judge improperly limited the cross-examination of Dr. Rosendorf. In particular, the defense is arguing that Rosendorf, after he left Theranos, worked at 3 labs. Those labs were PerkinElmer, Invitae, and Ubiome as a lab director. All 3 of those labs have been undergoing or have been investigated. So I think the defense was arguing, and they did it in trial, they're arguing to get that evidence in because they're basically saying that Adam Rosendorf was the problem here, right? Because if he leaves Theranos, he goes to 3 other labs, and those 3 labs are investigated too. So is Adam Rosendorf basically a knucklehead? Is that, and it's his fault that there were issues, there were reliability issues with the blood results? It was Rosendorf's fault. So we'll have to see again what the prosecution says. And again, this issue could be interesting because in the 6th Amendment of the U.S. Constitution, defendants have a right to confront witnesses. So if the defense is successful in arguing that because this judge limited their ability to cross-examine, to get in this biased testimony, to talk about, it's basically character evidence, that regarding Rosendorf working at subsequent labs, those labs also having issues, whether or not that violates the Confrontation Clause of the Constitution. I mean, whenever you're dealing with constitutional issues, the Court of Appeal is very thorough, pays particular attention to that. So this issue might be interesting if the defense can flesh it out a bit more, and we'll have to see again what the government responds to that. So the other thing, that could be argued, I'm sure the government's going to argue, hey, it's not relevant what happened, and we don't know the nature of the investigation of those other labs. What matters here is what happened at Theranos, and that's what the jury considered. So again, we'll see what happens. All right, so there's also I call them the driveway statements. You remember when Adam Rosendorf showed up at the driveway of Elizabeth Holmes after the conviction and said to Billy Evans, her partner, that Adam Rosendorf doesn't deny this, but he said that, the prosecution made things look worse than they were. And so the defense was arguing, they asked for a new trial for this reason. They were arguing that Adam Rosendorf is basically recanting his testimony and that they should be given a new trial for that because he was a key witness. He was central to the government's case. Well, as you remember, the judge granted them a hearing. They put Adam Rosendorf back on the stand. He denies he was recanting. He denied he lied. He explained more about the circumstances, and the judge denied the request for a new trial based on Adam Rosendorf's driveway statements. Okay, so I don't think that one's going to be particularly compelling, but we'll have to see if the confrontation, if a constitutional question gets caught up, we'll have to see what the judge thinks about that. All right, so Wendy Old Bird, hello there. Didn't receive notice. Oh, sorry about that. I sent out, it's posted on community. Who knows what's going on with this channel. All right, what happens in the driveway stays in the driveway. Well, actually, it didn't. NQK. No, NKQ. Are you a subscriber? Please do subscribe. So actually, it didn't stay. And what happens in Vegas doesn't stay in Vegas either. You can ask OJ about that. What happens in this driveway stays in the driveway. Nope. Actually, there was a hearing. And it was denied as a reason for a motion for a new trial. Okay, so number 8. This is the misrepresentation that did I skip? Let me make sure. Yeah. So the representations made to the investors regarding Theranos' relationship with the Department of Defense. The defense is arguing that's an error that the judge allowed that testimony to come in. Dan Edlin testified about the relations, the agreements, the contracts that they had with the Department of Defense. The defense said that should not have come in because all of that PowerPoint presentation that Dan Edlin was referring to took place a year and a half before these investors invested in Theranos. The investors that are the 6 investors that are part of the indictment that she was tried on and convicted on, 3 of them, plus the conspiracy to defraud investors. So defense also argued that the prosecution failed to make a coherent theory in closing argument as to why the misrepresentations to the Department of Defense were part of the scheme. Well, my response to that is, well, you could have argued it in closing. The defense could have gotten up and pointed that out to the jury. So I don't know how successful they're going to be on that argument either. Okay. And regarding, they're saying that the government also never disclosed that they intended to present evidence regarding the Department of Defense. Well, it's in the indictment. That would be my response. Read the indictment. Okay. So I hope the judge says, no, I don't remember everything I read, but I didn't think she qualified. Well, you know what? I watched the trial, and sometimes the stuff that was reported, I have a big question mark about. And I know it, I know they're trying to capture people's attention and sell, subscriptions and everything else, but it's one thing to be there and it's another thing to report about it. Okay, so hit that like button, you guys. If you want to send me a super chat, support my work, there's a link in the chat box, and I'll put a link in the description box below the video. Ask your questions. I'm here live. Okay, so let's get to number 9. So we got 2 more. This is number 9. They're arguing that this is an interesting argument. I don't think it's going to be successful, but I'll tell you about it anyway. They're arguing that the government changed their characterization of the relationship between Elizabeth Holmes and Sunny Balwani in the Holmes case versus how they characterized it in Sunny Balwani's case. So the defense is arguing it's new evidence, which is what they argued in their motion for a new trial, which this judge denied. But they're arguing in the Balwani case, the new evidence was that in closing argument, the government said that Sunny Balwani was influencing Elizabeth Holmes. Remember, he was tried separately. So Sunny Balwani was influencing her. He was older. He had more business experience, which is what the defense was trying to argue in the Elizabeth Holmes case, basically by pointing the finger at Sunny Balwani. But in the Elizabeth Holmes case, the prosecution argued, no, they were equal partners. They made decisions together. It's a conspiracy case. So because the defense is arguing, because they are now saying in the Balwani trial, in closing argument, that it was Balwani who was the one who was influencing. He was the one making those decisions. Therefore, because they changed the characterization in closing argument, it's new evidence. Well, the judge denied it, and I think he's going to deny it again. All right, number 10, the last one. This is back to that darn LIS database. Comes up again. Number 10th reason, and I think there's an 11th one. I'll get to that in a second. So the 10th one, let me look at your questions. She basically asking the judge to say he was wrong. Yeah. Well, or that he made a mistake, or that, things do happen. But a lot of times you want to bring these motions just to make sure you cover all the bases, to outline the appeals. There might be some new information that shows up in this hearing that might be helpful for Elizabeth Holmes in her appeal, or maybe helpful to the government in their response to the appeal. We'll have to see. You never know. This case and cases, you never know what's going to happen, and we'll have to see. Okay, and again, just to remind you, as far as I know, it looks like that the hearing on this stay-at-home motion is going to be March 17th, not this coming Monday. But I'm waiting for the judge's order or an indication that the hearing is set on March 17th. But because I'm sure it's more than likely going to be March 17th, because both sides have already agreed to that. Okay. So, all right, the 10th, the last item, although the 11th I'll get to in a second, that the government failed to produce the LIS database. And again, this was brought up and the court denied it in the motion for a new trial that was heard, I think, it was it was heard in December, I think. So they're saying that there was new evidence because after the trial, the defense discovered that there were emails between the prosecutors and between their technology department regarding the database. Did they have the access code, which turns out they didn't. They weren't given the access code by Theranos. So they never opened up the database to find out what was in it. And the defense keeps arguing that the government failed to preserve the evidence. But the thing is here, you still have to show that the prosecutors acted in bad faith. And because there's emails between the very same prosecutors who tried this case, same prosecutors tried both Balwani and Holmes, different defense team, same judge. But the standard to show that the government acted in bad faith, it's one thing if they opened up the database, found out that it showed that all these tests were reliable, that they did a lot of quality control, and then they didn't produce it. That's a whole nother story. But the prosecution has always said they were not able, because they didn't have the access code, right? It was encrypted. They weren't able to get into the database to find out whether it was going to be helpful or harmful or whether it's incriminating or exculpatory, okay, towards Elizabeth Holmes. The government might say, well, maybe you could have called an expert in the trial to explain how the database, I don't know if it would have been allowed because the judge was very limiting as to what testimony came in regarding this database. But that bad faith standard, showing that these prosecutors acted in bad faith, I don't know if they're going to be able to meet that burden. And in the motion for a new trial, the judge found that these prosecutors didn't act in bad faith. So that's going to be tough. All right, let me look at your questions. Fungi, they keep using the same arguments again and again. Well, actually, they're trying to see if there's anything else they need to cover. And they're laying a record so that when it goes to the Court of Appeals, it's very clear on what the issues are. They're filing the appropriate motions, right, to test the evidence, test the convictions, test the rulings. Fungi, okay, let's see here. Will any of the letters sent to the judge have an impact on custody while appeal? No, that was already decided regarding the letters that the judge received during sentencing. No, that's already been considered as far as the sentencing goes. There will be a restitution hearing. They still need to determine what the amount of restitution is that Elizabeth Holmes, and by the way, Sonny Balwani, have to pay back these investors and patients as far as Balwani goes. So that's going to be a separate restitution hearing. The judge may set it at the March 17th when he hears the stay-at-home motion. We'll have to see when the restitution, and that's when the government has to prove out what the damages are. That's an evidentiary hearing. So whether it's going to be letters that they received from the investors and the patient, or as far as Elizabeth Holmes, letters they received regarding from the investors, or what's in the pre-sentence report, I don't know, because the pre-sentence report is confidential. Okay, those letters failed to get our leniency. Well, I think people might argue differently on that because she was convicted in January of 2022. She wasn't sentenced until November. The judge could have sentenced her based on the amount of loss. I mean, he picked the low end of the range, which I understood, or was it the high end? I think it was the low end. He could have gone higher. The prosecution, I think, was asking for 15 years with Elizabeth Holmes. And they argued that there was certainly enough evidence to support that, or the damages, deterrence, all of that. But the judge, went kind of in between with the probation was recommending 9 years, I believe. And the government was recommending 15, and the judge came in 11 years, 3 months. So leniency, some people, 11 years is a significant jail time. Prison, I should say prison time. Okay. It's confusing as to the conspiracy counts, as I understand. Elizabeth Holmes was convicted on one and Sunny Balwani on two. Yeah, well, the jury heard the evidence, and there were different jurors, and they made a decision based on the evidence that came in on Elizabeth Holmes' trial that she wasn't guilty on any of the patient counts. That relates to defrauding patients, the conspiracy count, and relates to the 4 counts relating to the patients. She was acquitted on those counts. She was not convicted. Okay, let's see, who was Sunny Balwani supposed to have conspired with on the count? Well, evidence was different and presented and argued differently in the Sunny Balwani case, and that jury weighed the evidence. Look, here's the bottom line. When a defendant takes the stand like Elizabeth Holmes did, and I know a lot of other people out there, I'll call myself a talking head, other talking heads are out there saying, oh, no, she's not going to take the stand. I'm like, yes, she is. She's going to take the stand. I knew she was going to take the stand, and I told you guys she was going to take the stand and testify. How did I know that? Well, when you try a bunch of domestic violence cases and child abuse cases, and you're a prosecutor for many years, there's a certain kind of personality that takes the stand. And Elizabeth Holmes has the one thing that she values is that this is the technology that she created. She created this. She has always said, they have always said, the reason there were issues with the accuracy and the reliability of the testing was because it was the employees, whether it's Rosendorf or other people working in the lab. In other words, it was human error, it had nothing to do with her technology, because that is the one thing that Elizabeth Holmes values the most. This technology worked according to her. So she took the stand for 7 days. I was there. She testified. She subjected herself to cross-examination, which a lot of jurors, when you put your client on the stand, you're doing it because you want the jurors to know who your client is. I mean, as much as you can, as long as they're on the stand. But when they see the defendant testify, they're paying attention. And when you have somebody like Elizabeth Holmes, who was able to get, I don't know, was it 600 million from investors over the years? She knows how to, let me just say, work a room. Okay. So the thing about the testimony was the key was the cross-examination of Elizabeth Holmes. And the jurors, maybe there was sympathy for her. I don't know. We're not going to know unless there's some juror misconduct allegation in the appeal, unless there's some reason as to some juror comes out and says that misconduct took place, like in the, that they tried to argue in the Scott Peterson case unsuccessfully. But we don't know. We don't have a right to know what was going on in the deliberations. We don't know why the juror decided to convict her on the investor counts and not on the patient counts. Sometimes it's a compromise. There could have been 1 or 2 jurors. And again, I am way speculating here. There could have been 1 or 2 jurors that said, hey, you know what? I don't think she committed fraud as far as the patients. She wasn't in charge of the lab. Sunny was there. Look at all these texts between Sunny and Elizabeth. He was on site. He was the one making these decisions. She was busy raising money. So we're not going to convict her on the patient counts, but we're going to get her on the investor counts. That investor call. You can look at the video I did on the investor call, where, by the way, she was talking about the Department of Defense, the medevac, using the technology in the medevac on that investor call. So, you can make the decision whether that was a misrepresentation relating to the Department of Defense. Okay. So thank you, NKQ. Okay. Do you think this judge has a lot of patience? Yes. 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 Judges have to have a lot of patience. Okay. Especially, in federal court, it's a lot more formal. And they tend to have, let me put it this way. They have a volume of cases, but they don't have nearly the volume. And again, the federal cases, when you're dealing with RICO and wire fraud and all that stuff, money laundering and trafficking, those can get, a lot complex, take a little bit more time than, say, for instance, your DUI, or maybe your child abuse case, or maybe your domestic violence case, or maybe a bar fight, or maybe a theft trial. The county judges, the city judges, have quite an extensive calendar of cases to get through. So the workload is different, but a judge with patience is a good thing. Okay. So that, both the defendant knows they have a fair trial and the government knows that they've had a fair trial. Okay. So the 11th reason. Okay. I'll read it to you. You ready? This is the 11th reason Elizabeth Holmes wants to stay at home. Release will facilitate Ms. Holmes' continued communication with her counsel as she litigates these issues on appeal. So in other words, the defense is arguing, Judge, let her stay at home because that facilitates our communication, counsel's communication with Elizabeth Holmes. Well, last I checked, counsel can go to prison and talk to their clients. There's phones, there's emails. So I thought that was kind of interesting. Defense attorneys all the time go to visit their clients in prison and communicate with their clients in prison. So I don't think that's going to be very persuasive. All right, let's see. If Ghislaine Maxwell didn't get a new trial despite a juror obviously being prejudicial, I doubt Holmes will get anything on the juror. Well, there isn't anything suggesting in the Holmes case that there was any issues with the jury. I was just throwing that out there as a hypothetical. There's been no evidence of any jury misconduct in the Holmes case. Okay, any other questions out there? Go ahead and post them in the chat. And I also thought it was interesting that in this motion, the defense said that the record, basically the trial record, the record is teeming with issues for appeal. And the other thing is they said that Ms. Holmes, she may raise these issues on appeal. Well, factor number 3 says the appeal will raise, wait, hang on a second. Yeah, the appeal will raise a substantial question. Well, but in the motion, she's saying she may raise. How about Elizabeth Holmes will raise these issues, the following issues? And again, they're still working, the defense is still working out as to what issues they're going to be appealing, and now they can also consider the sentencing. Was the sentencing calculated properly? I mean, I think it was, but is that going to be an appeal issue? Because if you remember in the Jeff Schilling case, the Enron CEO, who was convicted and he was sentenced to 24 years in prison, he appealed and he won on the sentencing issue because the Court of Appeal found that the judge made an error in the sentencing. So it was sent back to the trial judge to re-sentence Jeff Schilling. And during that time, the prosecution offered Schilling a 14-year deal, which he took. So because of the appeal and because of the Court of Appeal's decision, his prison sentence went from 24 years to 14 years. So maybe sentencing is going to be an issue on appeal. We'll have to see. Okay, so any other bluffing? Yeah, like they can't contact her in prison. Yeah, that's what I said. That's what I said. Okay, let me see if there's anything else. Any other questions? Okay, any other questions, you guys? Anything else? You guys want to talk about anything else? I do want to, if you want, send me a comment send me a comment if you want me to do a live on the Idaho murder Brian Kohlberger case, because I think I have a few things to say based on some things that I've been reading that I think are interesting. I'll leave it at that. Okay, you missed a question. What was the question? Pungai Fung, he still went to prison. Yeah, he still went to prison, but because of his appeal and because the defense filed an appeal challenging the sentencing calculation, he got a deal of 14 years. He wasn't resentenced by the judge. He took the offer by the prosecution. Okay, Pungai, Holmes wants to avoid prison in the worst way. Well, I don't know. Look, like I said, these motions are pretty common. If you're, a good defense attorney, you pursue these motions to ask for her to stay at home. Okay, and any defendant who's convicted and is looking at prison time, however long, can file this motion. In the United States, we have the right to do that. Okay, and we have judges to make a decision applying these 4 factors, whether or not she's going to meet these 4 factors. And even if she meets these 4 factors, it's still up to this judge. It's in his discretion. They can certainly appeal this judge's decision. And by the way, that brings me to the questions that you guys asked me. So let me get to these. So David Anderton, thank you, David, for this question. David, are you a lawyer? Are you in law school? Because motion for relief, it's actually a motion for release pending appeal. So he asked, if Elizabeth Holmes' motion for relief is denied, can she appeal to the Ninth Circuit? Yeah, she can appeal, or more likely appeal for an expedited hearing on a motion for a new trial. Well, she's already done that. She already lost. Okay, and it's too late for her to appeal that decision. That time's passed. So they can go ahead and try to appeal this judge's ruling. I don't know that they're going to do that, given that their opening brief is due March 3rd, March 5th. And a lot of these issues they can raise with the Court of Appeal. Okay, but David, thanks for that question. And thank you for subscribing and supporting Michele's analysis. Okay, Pictor said, Holmes will be sent to prison. Her crimes are serious, involving hundreds of millions and continuing her fraud scheme for years. The health of the people were put at risk. Yeah, isn't that an interesting, timely issue these days? Health of people put at risk through her scheme, and she never admitted her guilt. Well, at sentencing, she did stand up and address the court, and some people will argue whether or not she was taking responsibility by what she said. Other people will say, yes, she took responsibility. But my issue is that she was on the stand for 7 days and didn't take responsibility. And I kept saying, she hasn't shown remorse. There's no remorse. There's no taking responsibility. She had 7 days to do it. And it could have impacted her convictions. Okay. And, keep in mind, Balwani was convicted on this too. It's not just Elizabeth Holmes. And she went public with Theranos in 2013. It was stealth. From, I think, 2009 to 2013. They were still trying to work out the technology and stuff. Okay, but Pictor, thank you for subscribing. Thank you for your comment. All right, so Aussie Girl. She doubts that the judge will let Holmes stay at home. I agree with you. I doubt the judge is going to grant this motion. She said if the Chrisleys couldn't stay at home, even though the appeal held weight, Holmes's appeal doesn't hold any weight. Well, we don't know what the appeal is yet. We haven't seen the issues. These are issues that she may raise. And in the Chrisley case, and again, I didn't follow it as much. That's a different judge. And it's the judge, judges have discretion. This judge obviously was there during the trial, made the decisions on whether evidence comes in or out. He watched the witnesses testified. I'm sure he evaluated the credibility of the witnesses, just like the jurors were doing that. All right. Catherine, thank you for your question too. I think it's Catherine Lagrimas. Her comment was, Holmes is trying to prolong the process, staying out of jail for as long as she can. Everybody, I hear so many people saying that. When I look at it as a lawyer and I say, no, she's just like every other defendant. She's filing an motion every other defendant would file and asking the court, hey, judge, can you consider allowing me to stay at home? And again, in the sentencing recommendation by the defense, They were asking for home detention. So that's basically the same thing. Okay. She's asking basically to stay at home while the appeal decision is pending. I doubt it's going to happen. I really doubt it. Catherine goes on to say she should pay her dues to society. Prison is looking a bit grim. I may be wrong. Well, keep in mind, this prison doesn't have any fences around it. It's not like your maximum security, the kind of prisons you see in jail. This is what's called a prison camp. They're allowed a lot of educational resources. There's a library. There's a lot of other high profile defendants who are also sent to this women's prison camp. It's it's not that how do I say it? It's not that harsh of conditions. And you can go to the Bureau of Prison, by the way, and you can look it up. It's at Bryan, Texas, Bryan, Texas. You can look at the picture. You can read all the stats. I did I think it's in one of the videos when I was talking about her sentencing. I gave you some stats on the Bryan prison. I think there's only 200 or 300 inmates. It's dorm style housing. So it's not that grim of a facility. Let me put it that way. And Catherine goes on to say, I may be wrong, but we'll find out soon. Thanks again for your analysis, Michele. You're welcome, Catherine. Thank you for subscribing and supporting Michele's analysis. Okay. Ms. Holmes she will appeal until the sun goes. Well, most defendants do, right? They're going to challenge it. You have a right in the United States to file these appeals, right? Because what's the alternative? The alternative is your liberty, your life is taken, right? Because you're in prison. So your liberty is taken. So in this country, in the United States, defendants are given rights, and we're lucky to have them, where we have the right to, defendants have the right to remain silent. They don't have to prove their innocence. You're presumed innocent until you're found guilty. Elizabeth Holmes and Sunny Balwani were found guilty. They have the right to file motions for a new trial, motion to stay at home, ask for leniency, motions to suppress evidence, keep certain witnesses out, keep evidence out, all of that. Okay, it will not be like the one in Charlie's Angels episode. Yeah. I think you're dating yourself there. Fun guy. Anyway, that's a funny comment. Is such a facility more rehabilitative than punitive? Yeah. It's definitely more. I mean, prison is supposed to be rehabilitative. Isn't that what our common goal was? Yeah, it's basically, they can get education. I'm sure Elizabeth Holmes is going to be writing a book or two, as to what happened in the trial, or tips on going to trial, or and it may just be a bestseller. I don't know. Maybe she's going to be working on her chemical patents. I mean, she has, I think, hundreds of patents. And she has a great desire to prove that she is innovative. So maybe that's what she's going to be doing. And again, she's not going to serve all 11 years. I think they serve about 85% of it. So, and that's assuming, the appeal, there are no issues on the appeal. In other words, the appeal, the judge upholds all the convictions, right? Because the conviction's not final until the appeal's final. All right, any other questions? People pay to go to the worst places. Well, some people might say, Alan, that it was quite the lifestyle that both she and Sunny Balwani enjoyed. Okay, these are crimes of money, defrauding people. They'll argue it was innovative technology. They were trying to change the healthcare system. They were trying to make things affordable for everyone. Other people would argue, now, con artist, you scammed people out of hundreds of millions, lied until, fake it till you make it. Bestseller in the historical fiction category. That's funny. Okay, any other questions, you guys? Anything else? And do send suggestions if you have other lives you want to do. Again, I would like to do a live, assuming I have time, on the government's response to this motion to stay at home. I'm sure they're going to have some really interesting arguments. And also, I'd like to do a live on the Idaho murder case. I think, a lot of the stuff that's being reported, I have questions about. So, anything else? Shall we sign off? Shall we call it an evening here? Any other questions, anybody? So, all right. So I want to say thank you again to all of you for supporting my channel, or I should say our channel, our analyzers. So Michele's Analysis, thank you for supporting this channel, and thank you for subscribing. Please do subscribe and support my work. I appreciate it. And if you want to contribute, there's a PayPal link in the description box and in the chat box. Oh, fungi. How about Sam Bankman-Fried? Well, what do you want me to talk about on that one? Sam Bankman-Fried's case. Yet another alleged fraudster. Fungi. What do you want to know about Sam Bankman-Fried? A lot of it's in the press. And I also I'm curious to see what they're going to be doing next in that case. If it gets interesting, then maybe I will do a live. Maybe I'll post a video or two. At this point, I still think there's a possibility that he might take a plea deal. That's the short of it. He and Holmes have a lot in common. Well, there's a lot of fraudsters out there. Think about it. Information that came out that may not have been correct, may have been misled about things. Fraud is the crime of the moment. And, when people are motivated, money motivates people, especially greed. And they could end up, when they make, fraud is making misrepresentations, basically lying to people. And in the case of wire fraud, lying to them to get their money based on some product that you created. Okay, so any other questions? Is that it? Call it a night? A phony public persona that took precedence over. Yeah, well, if you notice these days, it's all about branding. So they, as far as Sam Bankman and Elizabeth Holmes, these younger people, are displayed in the media as these innovative, Steve Jobs type characters. It's like all the hype, the brand, they become the brand, and people buy into it. They jump on the train because everyone thinks they're going to make a lot of money, a lot of profit, and I guess people just don't know to ask the questions to find out whether or not the technology actually works, whether or not where the money is being invested, all of that stuff. Due diligence. I mean, even in the SBF case, Sam Bankman, the FTX case, the cryptocurrency, the hedge fund, the Alameda Research, there was no board of directors. No board of directors. And people invested. Also, the Stanford connection. Yeah, well, there's you can do your own research as to why this is happening. Okay, it's very interesting. Okay, so that's it. Thank you, everybody. Thanks again. Thanks for joining me for this live stream on this holiday weekend. I appreciate it. And thanks again for all the wonderful chat, for all your questions, your analysis, the questions that you sent, for voting in the poll, and for supporting Michele's analysis. So have a good week, everybody. And thanks again for watching.